In light of a recent Herbex Slimmer's finding by the Advertising Standards Authority, consumers might be asking what are the real legal implications of false advertising. Now, the ASA, the Advertising Standards Authority, found that the brand was making unsubstantiated claims about their product and weight loss. In response, the Herbex brand took the ASA to the High Court and won. The High Court held that the ASA had no jurisdiction over non-members. So there's a conundrum here. What are the wider implications? Abdurrauf Kamar is a trademark associate with De Beer Attorneys and joins us on Mags on Media. Welcome. So this is a long-running and fairly complicated legal story. I want to try and break it down if we can. So it's been ongoing for 4.5 years. What were the initial claims that Herbex was making?
So firstly, Jeremy, I think that we have to look at this in context. As you said, as you rightfully pointed out, this has been coming out for a number of years now. So it started out with a simple complaint being laid by a gentleman by the name of Mr. Steenman. He said that the actual product, Herbex, it doesn't carry a snowball of weight, merely saying that what is being showed, what is being advertised, it's not true. There's no factual basis on it. So along those lines, it's false advertising, right? The ASA then took the matter further, asked Herbex to substantiate whether these claims are true. Do they have any evidence to substantiate it? Herbex in turn said, listen here, the ASA doesn't have jurisdiction, and the reason for saying that was that they're not a member of the ASA. They then took the matter further to the High Court. At the High Court, Herbex claimed and said that the ASA doesn't have any jurisdiction over them, and the reasons for saying that was that we're not a member of you. You guys are trying to, it's as if you guys are saying you're organ of state and you have statutory powers, which is a very broad and bold statement to make, because they're not an organ of state, if you want to hear me.
But they never denied the actual claim that was being challenged.
They never ever substantiated. They never provided any evidence with it, so they never ever took it on that basis, no, Jeremy.
And for 4.5 years, it's been a very expensive process, hasn't it?
Absolutely, Jeremy.
So it would appear then that if you are not a member of the Advertising Standards Authority, you can say what you want, or is there other recourse?
So on the face of it, Jeremy, that's exactly what it says, and that's what's getting all the entities so excited. So basically, if we're not a member of the ASA, we can say what we want to say, basically, right? From the High Court, this matter was taken further to the Supreme Court of Appeal. So what they said was where the ASA has no jurisdiction over non-members, which is a bold statement. So basically, as we just discussed now, you can say what you want to. False advertising is basically okay, to put it in a nutshell, right? The matter was then taken to the Supreme Court of Appeal. The Supreme Court of Appeal said, you guys are right in saying that the ASA has no jurisdiction. They can make rulings, however, those rulings aren't enforceable. As the ASA, it's a voluntary association set up in terms of the Companies Act. The ASA is allowed to make rulings, but those rulings are not enforceable.
So the only recourse if you have a complaint about an organisation that is not signed up to the ASA is within the court of public opinion?
Absolutely, Jeremy. I think what a lot of people are not probably getting, or what they're misconstruing, is if they are making these false statements, a lot of our big brands and advertising, they all form part of the ASA. So if you as a non-member, even if you go out and you false advertise, no one that's a member of the ASA is going to publish what you're saying. So at the end of the day, you're still losing out, if you're with me, Jeremy.
Would it be your contention that most reputable major blue-chip brands in this country do subscribe to the code of the Advertising Standards Authority?
Absolutely, 100%, Jeremy.
So Herbex here would be out on a limb?
They are out on a limb, that's correct.
So in terms of going forward then, given the court rulings, surely this opens the floodgates for people to say whatever they want to say.
Exactly. That's why it was held in the Supreme Court of Appeal. Something that was also rather disturbing, the Supreme Court of Appeal, they didn't make the order out of their own volition. It was an order made between Herbex, basically an agreement between Herbex and the ASA that came together to a conclusion, and the Supreme Court of Appeal made that an order. But it would have been interesting should they have not came to this agreement and to have seen what the Supreme Court of Appeal would have said out of their own volition and possibly taken the matter further even to the Constitutional Court, because I do believe that things could have been very different had it become or come to that stage.
Could this still end up at the Constitutional Court?
At the moment, not. What currently stands is what's at the Supreme Court of Appeal, and that's the precedent going forward. Other brands now, whoever does false advertising, they would use a decision that was come at the Supreme Court of Appeal as precedent going forward.
What is to stop brands simply leaving or not abiding by the ASA and going out on their own?
Well,
is that likely to happen?
But what happens, Jeremy, is as soon as the ASA makes a finding, right? Previously, they used to put it up on their website,
yes,
and it was in the public domain and in the media. Now, with this new rulings, it's not as simple to do that. And another thing is this, the ASA previously, they didn't make it clear to clients when they sent a letter of complaint to an entity. They didn't inform them that you don't have to adhere to the process. Now they have to make it clear to people that are non-members of the ASA that you are not obliged, you don't have to conform to the process. If you don't want to, you actually don't have to.
Does this render the ASA, in your opinion, completely toothless now?
I definitely won't say it renders it toothless. What I would say is that people have to be wary of the fact that even if you are doing false advertisements, you're not going to get the publication that you want if the ASA rules against you, because their rulings are still binding on their members. And as long as it's binding on their members, the non-members...
Fair enough, but I mean, the key phrase there is on their members.
There we go.
However, what could happen if people still wanted to pursue the Herbex case, and work with me on this one, I'm assuming they could pursue the matter without the Advertising Standards Authority. In other words, challenge the validity of those claims in open court.
You're 100% correct.
But it's very expensive.
There we go, absolutely. Remember, Jeremy, when we're speaking about High Court, right, we're looking at anything between 100 to 300,000. That is one of the reasons that the ASA is there, for a speedy remedy, for a cost-effective remedy. So, I mean, people don't want to go to the High Court. They don't want to go to the Supreme Court of Appeal. They try to avoid that at all costs.
It's disturbing.
It is rather disturbing. And I mean, it's going on a bandwagon, unfortunately, at the end of the day.
Okay, Abdurrauf Komar from the organisation De Beer Attorneys, thank you very much for joining us. I think it would be incumbent upon us now to get some response in coming weeks from the Advertising Standards Authority. Thank you for opening the debate.
Thanks for having me, Jeremy.
And coming up on the programme, the thinking behind a newly launched movement tapping into a renewed sense of hope and optimism, currently being shared by many South Africans.